So looking at what I have on my screen, you can see that this university that we'll be mentioning here on this channel has come out to confirm that they once offered admission to a Bola Tinubu who is a female. That's the kind of transcript they have in their possession. So that brings the question on how come we have this same name, who is a female, who is claiming that he graduated from that school. You know, they are now saying they offered admission and the transcript they have in the university is that of a female. So I will let Dr. Talk come in here to like analyze to us because like you can see, the court has also reserved judgment. Let Doctor just break down some of these things so that we understand.
The case in Chicago is becoming very, very interesting. The court has reserved judgment. He would have given judgment, the judge would have given judgment, but something came up. The lawyers of Chicago State University dropped the very big bombshell. They have admitted in court under oath that indeed, the transcript of the person that they gave admission is the transcript of a lady based on the document. Based on the document. That's number one. And more interestingly, why the judge backed off. The judge backed off because there were some slides I sent to you. You can begin to push the slides now. Why the judge backed off is because the judge learned that another court had given Mike, yes. It says that the judge became confused after Chicago State University lawyer Michael Hayes confirmed that the school had indeed turned in records to Mr. Enahoro Eba in 2022, but insisted that Mr. Tinubu, the Nigerian president, was the one who attended and graduated from the school. But the information here, which is confusing to the judge, is that the lawyer is saying that a man attended the school, but the document with the university is a document of a female. That is, the document that they used to give somebody admission in the university is a document of a female. But according to them, the person that graduated is a male. Look at paragraph 2. Mr. Hayes, however, said he could not explain the contradiction. And being the lawyer of the school, it means that the school says they can't explain the contradiction. And the school's administrators would not be able to state under oath. Nigeria, when I hear them, they can't state under oath that the certificate Mr. Tinubu has been parading was genuine or not. They can't say it under oath. And as long as they cannot say it under oath, nobody can hold them responsible. Now, it says, is the diploma authentic or is it a forgery? My client can't answer yes to either of those questions. The client is the university. Mr. Hayes is representing the university. Mr. Hayes says of Mr. Tinubu's certificate that he submitted to the Nigerian president to be Nigeria's president. What it means, Nigerians, as we stand here, is that Chicago State University has categorically said under oath through their lawyer, what INEC has, they can't confirm whether it is real or fake. If the issuer of a certificate cannot confirm what someone is parading, according to precedents in the Nigerian Supreme Court judgments, not 1, not 2, not 3, not 4, that case is a closed case. The person who submitted the certificate is a loser because the issuer of the certificate cannot vouch for that certificate. That's what it means. And now, see, where there is a very big problem is that the judge in this case found out that another judge last year gave Mike Enahoro Eba a subpoena through his lawyer to mandate Chicago State University to release all the record that Atiku is asking for. So when the judge found out that the document that is already in public space by Mike Enahoroeba was given to him through a court process, the man became afraid. He said he has to think. Give me the other slide. The other slide says that the man says he's going to seek advisement, meaning that he need more consultation. No, not this one. The next one after this. That he needs more consultation. Just keep going. I think there was one where the judge himself is saying that he needs. Okay, no, keep this here. On 17th of June 2022, Mr. Tinubu submitted certificate to INEC that he said under oath. You know, everything is submitted under INEC was under oath because it's affidavit. That he said under oath that what happened, that it was issued to him in 1979 and signed by one Elnora Daniel, purportedly president of the school at the time. Now, Nigeria, make on a listing, no. But Miss Daniel only arrived at the university in 1998. That is 21 years after the certificate had been issued. The person they say signed the certificate in 1979 only joined the university in 1998. But the funny thing is that I don't even trust this woman. She resigned from Chicago State University in 2008, following months of financial mismanagement scandal that engulfed her last month of her tenure. You see her now? A snake will always give birth to something that is long. I can't say yes, I am not under oath, like Chicago State University lawyer. I can't say no. But when you see a woman like this that has this kind of career history of mismanagement on fund, you can always be told that such a person can be bought. This Oluwole thing is not only in Nigeria. It depends on if you follow the same track, you can be. Do you get what I mean, Nigerians? Why is it that it is this same person that came 21 years after that had a whole lot of scandal in her administration, that her name is on a certificate that is in question? Nigerians, use your own brain. Use your own brain. Even if they don't give you your rights, even if you don't get the mandate, use your brain to know waiting day. Nigerians, let us use our brain. Go forward. The judge found out that there is a document that is already out on the streets, that is already made public. And that document that is already made public was released by the university to Mike Enahoroeba. And that particular release was mandated by another judge of competent jurisdiction. So that judge is careful the kind of thing he's going to rule, because Mike Enahoroeba did not steal the document. And the case is becoming interesting because if for any reason that particular document that Tinubu's lawyers submitted to the Presidential Election Petitions Court, if it is another forgery, it means that they lied under oath again. Because what this lawyer is also trying to say is that what they have in record is exactly what they gave Mike Enahoroeba. That is what Mr. Hayes is trying to confirm. That is what Atiku is going for. It means that what if the judge grants the prayer of Atiku, what they will give to Atiku is exactly what Mike Enahoroeba has. Now, Mr. De Gramont pleaded with the court to expedite ruling. This is Atiku's lawyer. To expedite a ruling on the subpoena application because Mr. Abubakar's window to submit brief to the Supreme Court was running out. The Nigerian president now has only 6 days left of the 14 days to appeal the tribunal's decision that affirmed Mr. Tinubu's election. He's talking about the Mr. Atiku, not president, former vice president. Now, you remember yesterday I was saying, are these people trying to use technical issues to delay the court in US? Because the time to submit appeal in Nigeria for the Supreme Court is counting already. From the day they give the judgment, they have 14 days, including Saturday and Sunday. 14 days. And that judgment was given Wednesday last week. So they have until the close of business, I think on Tuesday next week, to submit this appeal. Until close of business Tuesday next week. So are they trying to delay until after? If that judge did not rule for or against Atiku, for or against Atiku's prayer on time, then that judge deliberately, technically deny Atiku something that will help him build his case. Do you understand what I mean? So that is the whole thing. So far, the judge is being careful because the judge knows that he can't act anyhow. There is, Mike Enahoreba has already choked them by going ahead when they were not suspecting to get a court affidavit, to get a court subpoena, to mandate the university to release this document to him. So he has it. To knock off the appeal in the Supreme Court. And when they finished their audition, the Attorney General was, okay, I like your own. I like your own. Meanwhile, remember that these are the Supreme Court judges whom this guy used to say, your Lord, your Lord. Now he's their minister. And they are doing, this is a conspiracy theory that I'm building in my head. I didn't read it from anywhere, but I'm just thinking. And then when he's done auditioning them, there are going to be 7 of them that he will pick. He will send the name to the chief judge of the federation and say, these people is who I need in the panel. Okay? And then when they come to the panel, they will now pull what they have already auditioned before their honorable minister and use it to block off P2B and to block off Atiku Abubakar. And tell us that we don't have a case. And foist upon us people that we didn't vote for. And people that broke the law to become leaders of our country. It's a theory I'm building in my head. But let's keep it as somewhere at the back of our mind. This theory, I pray it doesn't play out. But it is not impossible what these people are capable of doing. Because they know that if they touch any of the evidence that has been presented to them, it smells that there is no way they can touch it without indicting their man.
Yeah, no, I have a question. My question is, what if they avoid touching this topic at all? Because it appears that was what played out at the tribunal. It appears they didn't even say anything because I can't remember hearing anything as regards to this forgery or submitting a wrong certificate. I didn't hear anything from the tribunal. I don't know if they said anything. Please, if you have any information about that. So assuming that the tribunal judges just intentionally decide to avoid touching it and then getting to the Supreme Court does the same thing. They just like skip this particular topic now and then give their verdict because their verdict is going to be final. Nobody can appeal it.
If you listen to what I was just saying now, you will notice that's what I was building into. When I say that now, the Supreme Court judges who wants to be in the good book of the government are privately, theoretically, auditioning the Attorney General, whom you know was yesterday the lawyer to the respondent, will now audition them to know amongst them how many of them that have more technical jargons that they will use to knock off this case. And the best 7 he will select. He will forward the best 7 through a back channel to the Chief Justice of this Federation, who will inaugurate the panel. Okay? And then the panel will be inaugurated and they will sit and do what they have assured the government they will do. That's why I said So they will now foist on us people who didn't vote and people who broke the law. We didn't vote them one and they broke the law two. But it is nice that Nigerians know it. That will not deter us from pushing out to the public domain what is already happening so that Nigerians will know. It took a man like P2B to bring us to the point of this awareness, this awakening, this verification. That's what you're doing. P2B used that word, go and verify. We have been verifying and we have found out the rots in our system that our granddaddies and daddies we are looking up to, that they are dirtier than we can imagine. Many of them, not all of them. And that it is their rot that is destroying our politics. They are endangering the future of the young people. They are holding on to power as if they will live forever. Because these Supreme Court judges, are they not hearing the mess that is happening in America? Let's put it this way. Let me put it straightforwardly. See what the appeal court judges did. Subpoena, I keep saying it here, people need to understand it. A subpoena must be signed by a judge. And you cannot take the subpoena that is signed, like in that hearing, by another judge to another court. It is that court that is sitting, that judge that is sitting, that will sign it and say, I am handling a case. And one of the counsels in my case, in the case I am handling, says that you have something that will help his case. And because we believe in the principle of equity, fair judgment, I am using my authority as a judge to command you to bring this particular piece of information that you have, which a petitioner or a respondent in the case that I am handling says that he or she needs. That is what a subpoena means. Meaning that the person you're mandating to bring that might actually not be willing. He's only doing it because if he doesn't do it, he breaks the law. It means that subpoena couldn't have been issued unless that court, the panel that sat in that court, had been inaugurated. Mike Nahoro Eba was brought in by Atiku under subpoena. The judges decided not to touch it, saying that he should have uploaded it with the petition. Which petition? The judges had not even been selected when the petition was submitted. The judges were selected on the basis of the fact that there is a petition they need to treat. Yet they blatantly avoided it because they know that what Mike and Nahoro Eba had came through a legal, law-fulfilled process. And yet they looked at the law in the face, turned it upside down, and knocked it out. And the likes of Robert Clark, a man that something tells me is either in his late 70s or 80s, or even in the early 90s, sat down with a national television and did not mention that. You see why I'm blaming the elders? A man like Robert Clark sat down and said that Labour Party is talking the issue of law, without remembering that indeed what Labour Party is saying is the truth, that the Electoral Act was not abided by, that the judges decided to go and use Electoral Act 2011 to judge this case instead of Electoral Act 2022. You see why I have a problem with our elders? You see also why I have a problem with our national televisions, who will bring lawyers like Robert Clark and be asking him, what do you think? What do you think? Why not print in their slide the sections of the law that INEC refused to obey and that the judges avoided, and put it in the face of those lawyers and say, tell us, explain this section of the law for us. What does that mean? You see why I have problem with our media too. Majority, on fault, almost all of them, they're just interested on who will come and play advert and give them money. You see? And that is why when someone said that we come to the YouTube to drive followership, viewership, and make money, I'm laughing. We on the YouTube these days are the authentic, organic, genuine, well-researched broadcasters. You had better take what we're telling you, because we don't have any other interest than to see good governance. If we're going to get corrupt, at least not now. We don't have anything to corrupt us than to give you the real news. I have spoken on platform upon platform. A lot of people think that I am a lawyer. I have to tell them I am not a lawyer. It's just that I am a scholar. Yes, I've read. I am well read, and thanks be to God. The doctor in my name is not honorary. I didn't buy it. I paid the price for it. And I was equipped on how to research information. If I didn't get anything from that training, I got ability to research, to read in between lines, to know when someone is lying, whether the person is a judge or not. And I can tell you that our appeal court judges were bought over. If I meet them on the street, if I see them on the plane, if I come into their office, I can look them in the face and say, Honorable Judge, explain to me Section 137 of the Electoral Act. Explain to me Section 48 of the INEC regulation. Explain to me Section 47 of the Electoral Act. Explain to me Section 63 and 65 and 60. All these things were the new amendments of 2011 that appeared in 2022. They avoided all of them.